I heard the grinding of heavy machinery before I even turned the corner onto my own street. That sound, metal teeth tearing into wood and concrete, doesn't belong in a quiet Colorado suburb on a Tuesday morning. But there it was, a yellow bulldozer sitting on my property, actively tearing into the side of my detached garage. My name is Detective Sergeant Marcus Holt, and I've spent 19 years on the force responding to property crimes. I know illegal destruction of property when I see it. What I didn't expect was to find that the person who ordered it was wearing a polo shirt with an HOA logo. Standing at the edge of my driveway was a woman I recognized immediately, Patricia Dunmore, president of the Clearwater Ridge Homeowners Association. She had a clipboard, a self-satisfied expression, and absolutely no legal authority to do what she had just done to my home. Before I tell you how this unfolded, I want to make sure you're subscribed to HOA Problems, because this channel exists specifically to help homeowners understand how property law actually works, not how an HOA board thinks it works. Hit that subscribe button and stay with me, because this story gets very satisfying. Let me take you back 4 months. I had submitted a written architectural request to the HOA to build a detached garage on the rear western section of my lot. The structure was a standard 24 by 24 foot garage, built by a licensed contractor, fully permitted by Jefferson County. I followed every single step. Patricia Dunmore acknowledged my request in writing. The board had 30 days under our CC&Rs to respond. 30 days passed, then 45. No response. Under Colorado Revised Statutes, Section 38-33.3-217, silence past the response window constitutes deemed approval. I was legally clear to build. The garage went up in 3 weeks. My contractor, Ray Tellis, pulled all required permits. Jefferson County inspected and signed off. I had a final certificate of occupancy in hand. As far as every governing body with actual legal authority was concerned, that structure was legitimate, lawful, and mine. Then came step 1 of what I now call the Karen escalation. Patricia appeared at my door, uninvited, 6 weeks after the garage was complete. She informed me, and I am quoting her directly, that the garage violated the aesthetic harmony guidelines of Clearwater Ridge. That phrase appears nowhere in our CC&Rs. I checked. I remained calm. I asked her to cite the specific section of the CC&Rs that the garage violated. She told me she didn't need to cite anything because she was the board president. I thanked her for her time and closed the door. I then photographed the timestamp on my security doorbell footage of that entire exchange. Step 2 arrived 12 days later. A formal violation letter, HOA letterhead, citing Architectural Control Committee Rule 7, subsection B. It came with a $750 fine and a 21-day compliance deadline. Compliance, according to the letter, meant removing the garage entirely. I ordered a certified copy of the full CC&Rs from Jefferson County's recorded documents that same afternoon. When I sat down and read Rule 7, subsection B in its entirety, I found something remarkable. The subsection addresses paint color and exterior finish materials on primary residences only. It says nothing, not a single word, about detached accessory structures. Patricia had either misread the document or was betting I hadn't read it at all. I drafted a formal written rebuttal via certified mail, return receipt requested. I cited the exact CC&R language, attached my county-approved permits, and referenced Colorado's HOA statute on deemed approval. I gave the board 14 days to withdraw the fine. I kept copies of everything, time-stamped and organized in a physical binder and a cloud-backed folder. Step 3 escalated things. I received a letter from a law firm, Cranfield & Moss, LLP, claiming to represent the Clearwater Ridge HOA. The letter threatened a lien against my property if I did not pay the $750 fine and begin deconstruction of the garage within 30 days. I read that letter 3 times. Then I called my real estate attorney, Daniel Fry. Daniel reviewed everything I had assembled and used a phrase I will never forget. They don't have a single legal leg to stand on, Marcus. Under Colorado law, a homeowners association cannot place a lien on a property for a fine that is actively under written dispute. The statute is clear. The board had skipped required procedural steps entirely. Daniel sent a formal attorney response to Cranfield and Moss, identifying the procedural violations, the misapplication of Rule 7B, and the deemed approval statute. He requested that all fine demands and lien threats be immediately withdrawn and that the HOA board provide a written explanation for the failure to respond to my original architectural request within the mandatory window. For 3 weeks, there was silence. I thought the matter might be resolving itself through the legal pressure. I was wrong about that. Step 4 was coming, and it would be the one that crossed an unmistakable line into criminal territory. I came home from a late shift on a Thursday evening to find fresh tire tracks across my backyard leading directly to the garage. Someone had accessed my fenced, gated property without my knowledge or consent. The padlock on my rear gate had been cut. I documented everything with photographs, a written incident report, and I pulled the footage from all 4 of my property cameras. The camera footage was unambiguous. Patricia Dunmore and another board member, Gerald Kipps, had entered my property using bolt cutters in broad daylight, walked around the garage, taken photographs, and left. They were on my private, fenced residential property without a warrant, without consent, and without any legal authority. In Colorado, that constitutes criminal trespass under CRS 18-4-502. I filed a formal police report, not with my own department to avoid any conflict of interest, but with the Jefferson County Sheriff's Office. I submitted the footage, the cut padlock, and a written timeline.
But there it was.
Patricia Dunmore and Gerald Kipps were issued criminal trespass summonses. The HOA board suddenly became very interested in resolving this matter quietly. But Patricia wasn't done. Step 5 arrived in the form of a certified letter notifying me of an emergency board meeting at which the full HOA membership would vote on levying an additional $3,500 fine and formally authorizing corrective action on my property. I attended that meeting with Daniel Fry, a printed copy of every document I've described, and a portable recorder, which is legal in Colorado under single-party consent law. Daniel addressed the board for 11 minutes. He walked through the deemed approval failure, the CC&R misapplication, the pending criminal trespass case, and a very important additional document he had obtained that week. A certified boundary survey conducted by state-licensed surveyor Angela Reese, confirming that my garage was built entirely within my legally recorded lot lines, with no encroachment on any common area or easement. Angela's survey came with a state seal and full documentation filed with Jefferson County. It was not an estimate. It was not an opinion. It was a legally certified measurement. The garage sat 11.3 feet inside my property line. The HOA had no claim, aesthetic, structural, or boundary-based, that survived contact with that document. Let me slow down here and talk about the legal tools that actually won this situation, because this is what I want every homeowner watching to understand and remember. The first and most powerful instrument I used was the certified property survey. When there is any dispute about what is on your land versus what is on common or shared land, a state-licensed survey is the definitive answer. It overrides opinions, photographs, and board member guesses. The second tool was the original CC&R document, obtained directly from county recorded records. Not from a PDF the HOA emailed me. Always get your CC&Rs from the county recorder's office. These are the legally binding, filed of record governing documents. Any version the HOA hands you may be edited, outdated, or selectively formatted. The third tool was the deemed approval statute. Most states have a version of this protection. When an HOA fails to respond to an architectural request within their own stated timeline, many state statutes, including Colorado's, treat that silence as legal approval. This is not a loophole. It is a consumer protection built into the law specifically to prevent boards from running out the clock on homeowners. The fourth tool was certified mail. Every single communication I sent went via USPS, certified mail with return receipt. That creates a legally admissible paper trail with exact timestamps. If a board member claims they never received your letter, a green return card with their signature says otherwise. Now, about that bulldozer. After the board meeting, Daniel sent a preservation letter to the HOA's insurance carrier documenting everything that had occurred. We learned through the carrier's investigation that Patricia had hired a private landscaping company and told them they had HOA authorization to remove an unauthorized structure. The landscaping company, Cruz & Sons Excavation, had no idea they were operating without legal clearance. They stopped the moment I identified myself. The HOA's liability exposure was significant. Unauthorized destruction of a county-permitted, deed-compliant, surveyed residential structure, combined with the criminal trespass summonses and the improper lien threat, gave Daniel enough material to draft a comprehensive civil demand letter. We were not seeking to punish anyone excessively. We wanted documented accountability and financial remediation for the partial garage damage that had already occurred. 3 weeks after that civil demand letter was delivered, the HOA's insurance carrier settled. All fines were formally withdrawn in writing. The HOA board issued a written apology acknowledging the procedural failures. The cost of repairing the garage damage, $4,200, was covered in full. Patricia Dunmore resigned from the board president position. Gerald Kipps did not seek re-election. Cruz & Sons Excavation, for their part, was never held financially responsible. They had been misled by the HOA and cooperated fully with the investigation from the moment I showed my credentials. Their foreman actually told me afterward that something had felt off about the authorization, but he hadn't known how to verify it. That's a lesson for contractors, too. Always obtain written, county-verified authorization before touching a residential structure. What I want you to take away from this is not that you need to be a cop to protect your home. You absolutely do not. What you need is documentation, knowledge of your CC&Rs as filed with your county recorder, awareness of your state's HOA statutes, and the discipline to respond to every HOA action in writing via certified mail and with copies retained in an organized file. The HOA board in this story was not defeated by my badge. They were defeated by a certified survey, a correctly read CC&R document, a state statute on deemed approval, a criminal trespass filing, and a real estate attorney who knew how to translate all of that into legal pressure. Every single one of those tools is available to any homeowner in America. The law does not care whether you are a detective or a school teacher or a retiree. Property rights in the United States are structural. They are recorded in your deed, protected by state statute, and enforceable through documented evidence. An HOA board can be aggressive, but they cannot override the law. And they certainly cannot authorize the destruction of a legally permitted structure because the board president doesn't like how it looks. None of what I've shared constitutes legal advice for your specific situation. Every property dispute has unique variables. Your state's statutes, your specific CC&Rs, your county's recorded documents. What I've described is how these legal frameworks structurally operate across American real estate law. If you're facing a serious HOA dispute, consult a licensed real estate attorney in your state. So here's what I want to know. Drop it in the comments right now. When you saw that bulldozer on my property, what would you have done first? Called the police? Grabbed your documents? Confronted the board president directly? There's no wrong answer, and I genuinely want to hear your instinct. If this helped you understand your rights, like this video, share it with a neighbor and subscribe to HOA Problems, because knowledge is the only thing standing between your home and someone who thinks a clipboard gives them authority over your deed.